Righto, good morning, everybody, and welcome to the March 2025 edition of the Family Law Roundup. Let me get my camera sorted, and then we are ready to get cracking. It's lovely to see all of you in this morning for the roundup, and I look forward to going through the cases with you. Some interesting cases emanating from courts all around South Africa in March 2025. From divorce through contempt of court to a Hague Convention matter in Cape Town, a domestic violence matter in Northwest, some procedure matters, maintenance matter, Rule 43s, children's matters, and then finally a matter regarding burial rights. So it should be quite an interesting set of cases that we are going to be going through. For those of you who are joining us for the first time, very, very warm welcome. I hope that you enjoy the presentation as we run through it. So for those of you who don't know, what is ThinkLegal? It's an initiative that aims to promote the open sharing of sound legal knowledge. As we all know, the delivery of legal services is essentially a commercial venture. However, we believe that legal knowledge is a public resource meant to be freely available to everyone. So therein ThinkLegal was born, and for this reason we are dedicated to facilitating open dialogue and sharing of knowledge among professionals. We organize a variety of activities, including our WhatsApp groups, webinars, and social events from time to time. I think we're quite overdue for a social event, but we'll see how that goes. For those of you who are interested, please visit thinklegal.coza. There you can register for events, join our WhatsApp groups. We have the Commercial Litigation and Labor Law WhatsApp group, the Event Notifications WhatsApp group, and then finally the Family Law WhatsApp group. You can purchase resources on our website, and you can also link to past webinars, which you can also find on our official YouTube channel. For those of you who are inclined to do so, you are welcome to purchase our optional course pack at 300 Rand. That is inclusive of the summaries, the bundle of judgments, and then you will get 2 SAAM, and I have omitted to fix up my slide, but once again, social justice has also reaccredited us for 2 CPD points, so you can get a SAAM or social justice branded CPD certificate for 2 CPDs for buying the course pack at 300 Rand. Now, the course pack is absolutely voluntary. You don't have to purchase it if you are keen to just sit in and listen today and find the cases yourself on Safely or wherever. You are welcome to do so, and you are still more than welcome to enjoy the session with us this morning. If you would like to, however, purchase the course pack, please go to thinklegal.coza. You will find the course pack there. I have also pasted in the comments and in the chat the link to the course pack for those of you who would like to go and pick it up. One more paid CPD training for the first half of 2025. The next one is on the 3rd, the 4th, and the 5th of June 2025, and that is our longest CPD training, Divorce 101, and this one is accredited for 6 SAAM CPD points, and our SAC SSP application is with our consultant and in progress at the moment. If you'd like to attend this training, the cost is 850 Rand, and you will get 6 SAAM CPD points for attending this training. You can go to thinklegal.co.za to register for Divorce 101. As always, thank you to those guys who support us. Lawbox Practice Management Software, try it free for 14 days, lawbox.co.za, and then also my colleagues at Vermeulen Attorneys for their patience as I excuse myself every few Fridays to present the roundup to you. So, all things considered and welcomes and admin out of the way, let's jump into the roundup and go straight into part 1. Right, first up, we have a divorce matter. NPM versus TRT and another. That is Johannesburg High Court ZAGPJHC 319. This judgment lands on the 25th of March 2025, penned by Norco J. For those of you following along, it is in the bundle on page 1 and it is in your summaries on page 1 also. This is an interdict pending finalization of a divorce matter. The applicant sought interdictory relief, restraining the second respondent, which was the GEPF, from paying out 50% of the first respondent's pension interest pending finalization of the divorce. The parties were married in community of property, and the divorce was instituted a few years prior in 2023. The first respondent had been dismissed from their employ on the 20th of February, and the precipitating factor for the interdict was that the GEPF may pay out the first respondent's pension benefits at any time. The aspects obviously covered in this judgment: Rule 612 of the Uniform Rules, urgency, requirements for a final interdict, which still goes all the way back to the late 30s, early 40s, Setlogelo versus Setlogelo, and then the requirements for an interdict or an interim interdict, Webster versus Mitchell. Then the court also had a good look at Section 77 of the Divorce Act dealing with pension interests in divorce. Finally, ultimately, the interdict was granted and the second respondent was interdicted from paying 50% of the pension interests to from paying out 50% of the first respondent's pension fund pending finalization. And the first respondent was ordered to pay the costs of the application on an attorney and client scale. The notable quote from NPM versus TRT can be found in paragraph 17, which reads as follows. There has been a concerted effort by the first respondent, argued the applicant, to delay the finalization of the divorce. And if the assets are not preserved, there would be no assets to share at the end of the divorce, which could possibly be in 2 years from the date of launching the urgent application. The fact that the first respondent has lost employment weigh in favor of the applicant that if she await launching civil action for damages against the party who is unemployed, the order may not be worth the paper. Worse, the prospects of employment in this situation are weakened by the bleak record predicating his dismissal. Can I just check from some of our other attendees? One of our attendees is saying that they cannot hear anything on their side. Can someone please indicate in the comment box whether that is a problem on their side as well? Or if you can hear me, just let me know that you can hear me, because obviously if you can't, then the problem is on my side. Okay, someone says they can hear me loud and clear. I think the problem is on your side. Val, please have a look at your sound settings, which obviously I am alive to the fact that you can't hear me saying that. Sorry about that. Right. Next up, we go on to TJM versus KJM and another. Also a divorce matter, and this one emanates from the North Gauteng High Court per Moshwana J on the 3rd of March 2025. This is a counterclaim for a forfeiture of pension interests and immovable property. The plaintiff instituted the divorce, and although before I go into that, just for those of you following along, bundle page 10, summary page 2, please go have a look there. The first defendant counterclaimed in this matter for a forfeiture of patrimonial benefits in respect of pension interests and a share in immovable property, arguing that these benefits being retained by the plaintiff would be disturbingly unfair. The court was tasked with determining whether the plaintiff should forfeit those patrimonial benefits in terms of the divorce which was sought. The other issues in the divorce had been settled via a settlement agreement, and the court was asked to deal with those settled issues separately. So really what the skirmish consisted of was the forfeiture claim. The court looked at Section 9(1) of the Divorce Act, obviously, and also went back to the Vaker versus Vaker locus classicus situation in terms of firstly determine that there is a benefit, and secondly determine whether the benefit is undue. In this matter, the forfeiture claim succeeds. The plaintiff was ordered to forfeit 50% of the pension interest held in the GEPF and 50% share in the immovable property. Paragraph 23 is our notable quote in this judgment, which reads, "In the circumstances, it is disturbingly unfair for the plaintiff to benefit from the property and the pension interest. He left the property almost 3 years ago and used the proceeds of his own pension benefits to acquire other assets outside the matrimonial home. He received his own pension benefits and did not use it to augment the value of the joint estate. Such a benefit for the half share of the property is certainly undue. Although the conduct of the plaintiff in encumbering the joint estate without consent and disposing of the assets of the joint estate without consent has not been pleaded as forms of substantial misconduct, when value judgment is exercised by this court, as it should, if forfeiture is not ordered, the plaintiff will be unduly benefited." And that is TJM versus KJM and another per Moshwana J in the North Gauteng High Court. Next up, folks, we go into the realm of contempt of court. And first up, we have RA versus IK, which comes to us all the way from the High Court in Cape Town per Boopchand AJ. You can find this on page 22 of your bundle and page 3 of your summaries. This judgment landed on the 19th of March 2025, and the judge in paragraph 97 of the judgment treats us to a little poem which I will read out to you a little bit later. This is a second application for contempt of court that arose from ongoing divorce proceedings between applicant and respondent, both of whom are medical professionals. The respondent had previously been found in contempt of a Rule 43 maintenance order and was sentenced to periodic imprisonment, suspended for 3 years on condition of compliance. The applicant filed a second contempt application alleging continued non-compliance with the order. The respondent in turn claimed financial inability to pay and a misunderstanding of the purpose of funds paid into a trust, and that took up quite a lot of space in the judgment. The aspects covered in this judgment, as with all contempt of court matters, Fakey versus CCII systems, which sets out the principles of contempt of court, the Plaskon-Evans rule, and HG versus AG, where shortfall in payment would be secured through other financial options. It does not constitute contemptuous conduct. The applicant did not succeed in having the respondent held in contempt of court, and costs were awarded, including the costs of a previous postponement. Paragraph 96 to 97 of this judgment constitute our notable quotes. Paragraph 96 reads as follows: the parties have put out their washing for the public to view. They have engaged each other in interim and expensive litigation, rushing to court in respect of issues that should have been objectively resolved before the institution of this proceeding, at the very least, is to be deprecated. The applicant should have realized that this application was misconceived. It was instituted urgently, despite her version being that the respondent had been in contempt of the Rule 43 order since August 2023, 1.5 months after the first contempt order. The parties should rather expend their efforts in finalizing the divorce. Good advice to any litigants, in my view. Now, paragraph 97, you almost want to read with a nice lilt in your voice. Contempt of court is not a finding lightly made, nor is it any easier if twice displayed. Context is the thread, the core of this tale. The peculiar facts and court order require scrutiny for justice to prevail. Two hearts once united now clash in spite. Hang not your linen for the crowd to pry in the courtroom's glare where tempers ignite. Resolve your differences, let the discord die. Why drift along the torrent of strife, engulfed in bitterness as incisive as a knife? Settle the storm, escape the gloom, grab the chance to heal and reclaim your purpose in this life. Judgment seeks not vengeance or ire, but the truth alone it does require. Interesting paragraph, to say the least. And I would like to hear your views in the comments on the poem which the court, per Boopchand AJ, decides to close off this judgment of RA versus IK in the Western Cape High Court. Next up, we remain in the Western Cape High Court. However, we deal with the Hague Convention on International Child Abduction. The judgment is JRS versus KDZS and another, and you can find it in your bundle on page 55 and on your summaries at page 4. The judge is Tulare J. This is an urgent application for immediate implementation of a Hague Convention order. The applicant, the father, brought an urgent application against the first respondent, the mother, for the immediate implementation of a Hague Convention order granted by the Johannesburg High Court in September 2024. The applicant also sought an order directing the first respondent to hand over their 2 minor children. In the previous proceedings, the mother had refused to return to Germany with the children after a family holiday in South Africa and was found to have unlawfully retained the children in Johannesburg. The aspects covered in this judgment per Tulare J include Article 1 of the Convention, the best interest of the child principle, and the recourse to appeal by the mom. The application was enrolled on an urgent basis, and paragraph 6 of the order of the Johannesburg High Court was to be implemented forthwith, and no order was granted as to costs. Paragraph 6 of the judgment is our notable quote, and it reads as follows. Considering that even a social worker and a family advocate, as well as representative of the German Central Authority, will all be strangers that may add to and not mitigate the anxiety and distress of the minor children, the approach of the family advocate is sound. The presence of the mother would help the psychosocial health of the children for the long travel. One can only hope that the parties in the interest of the children consider the views of the family advocate. It is easy for an adult to march into a child's residence with a court order in hand and a sheriff in tow and walk out with children screaming. It is another to seek to build a relationship with the children and, as a parent, enjoy the confidence and earn the smile and laughter of your kids looking forward to a long trip. And to Lara J., very astutely setting out the realities of Hague Convention matters for children and the anxiety and trepidation which a child must feel in these types of matters. For more background, obviously, please do go and read the case. As we always say in the Family Law Roundup, the summaries are for informational purposes and to fast track you into reading the judgments yourselves. This is a judgment that is worth reading yourself. Right. Next up, we deal with domestic violence, and we go all the way to the Northwest High Court in Mahikeng. The judgment is KAM and another versus SSM, and this is the Northwest High Court per Titus AJ. You can find the judgment in your bundle on page 61 and on your summaries at page 5. It is an urgent application for the suspension of an interim protection order. So what transpired is the following. The applicants brought an urgent application to suspend the operation of an interim protection order that was granted by the Mabato Magistrates Court in terms of the DV Act in February 2025. The IPO directed the applicants to return the Toyota motor vehicle registered to the respondent pending the return date of the domestic violence proceedings. The first applicant submitted their application was so urgent that it could not wait until May 2025 for the domestic violence applications and for the dispute around the vehicle to be decided, as the second applicant needs the vehicle for its business and the first applicant needs it for personal use and for the transportation of 2 minor children. The court looked at Rule 612 on urgency and 612B specifically on the requirements for a matter to be enrolled as an urgent application. The court looked at Mogalakwena Local Municipality versus Provincial Executive Council Limpopo and others, where the applicant must establish prejudice in an urgent application. Ultimately, the application was struck off the roll for lack of urgency, with costs to be taxed on scale A. Our notable quote is in paragraph 12 of the judgment per Titus AJ. Uniform Rule 612 makes provision for an applicant to create its own rules within which a respondent must file a notice to oppose an answering affidavit. An applicant must, however, seek the court's condemnation that the forms and service provided for by the rules may be so dispensed with. It follows that an applicant who cannot convince the court of the necessity for the timelines devised by it should expect its application to be struck from the roll with costs. It is then at liberty to set the matter down again on proper notice and compliance with the rules of court. Procedurally, the applicant fell short on convincing the court of the urgency of its application. That was KAM and another versus SSM, and that is the Northwest High Court in Mahikeng. Next up, we go to the realms of procedure, and this comes down to a declaratory order on interpretation of a settlement agreement. I see I have some of the people in who were in our drafting for divorce training, and I mentioned this judgment to them in that training last night and the night before as well. This is PYK versus TSK. That is in the North Gauteng High Court in Pretoria, and the judge is Botsi Tulare AJ. The judgment can be found in your bundle at page 68 and in your summaries at page 6. This is a cautionary tale in respect of the drafting of settlement agreements. The applicant sought a declaratory order that clause 3.1.1 to 3.1.8 of a settlement agreement dated March 2024 do not make payment a condition for transfer of the matrimonial home. She requested the court to appoint her own conveyancer, alleging that the respondent's appointed conveyancer acted in his favor to her detriment, causing delays. Respondent opposed the application, launched a counter-application seeking to amend clause 3.1.3 to specify how the purchase price should be determined, and clause 3.1.4 to give the applicant 6 months from date of divorce to purchase his half share in the property. The court was requested to interpret the parties' intentions in the settlement agreement. The court looked at section 21(1)(c) of the Superior Courts Act, which deals with declaratory relief. Shoba versus OC, temporary police camp Wagendrift for the principles or factors for a declaratory order. Cordian Trading CC versus Daimler Chrysler Financial Services, which sets out the two-stage approach for a declaratory order. And then finally, Natal Joint Municipal Pension Fund versus Endumeni Municipality on interpretation of contracts. The application in the main and the respondent's counter-application were both dismissed by the court, each party to pay their own costs in the main and the counter-application. Paragraph 17 sets out some of the court's reasoning in this judgment. A declaratory order is an order where a dispute over the existence of some legal right or entitlement is resolved. There must be a legal basis upon which the declaratory order in favor of the applicant can be made. It would not ordinarily be appropriate where one is dealing with events which occurred in the past. Such events, if they gave rise to a cause of action, would entitle the litigant to an appropriate remedy. The interest that the applicant should have is at least akin to the interest that a party has to intervene in the proceedings in the High Court, i.e., have a direct and substantial interest in the subject matter. The court declining to tell the parties what they meant when they signed the settlement agreement. That was PYK versus TSK on interpretation of settlement agreement post-divorce. Next up, we have HGW versus MW, Mike Whiskey, Knee B, and this is an appeal matter in the Western Cape High Court on the dismissal of an appellant's special plea of jurisdiction. The quorum in this matter is Van Sale AJ with Lekuleni J concurring. You can find the judgment on page 84 of the bundle and in page 7 of your summaries. The appellant sought an appeal against a judgment handed down by the regional court in Mossel Bay, whereby the court dismissed the appellant's special plea of lack of jurisdiction in the divorce action. The appellant in the regional court pleaded that the court lacked jurisdiction over the persons of the parties as required in section 28, 1 capital A of the Magistrates Court Act. Apologies to those of you who have the notes. Just at the last line of the overview, the word act is omitted, of the Magistrates Courts Act. Next up, we look at what was covered by the court. Obviously, the court looked at section 28(1) capital A, section 2(1) of the Divorce Act, being jurisdiction of divorce proceedings, section 1 of the Domicile Act, very importantly, domicile of choice, and section 19C of the Superior Courts Act, being remission of proceedings. In this matter, the appeal was upheld and the respondent was ordered to pay the costs of the appeal. Paragraph 13 of the judgment is our notable quote, which reads as follows. It is not necessary in the ordinary course to make any specific allegation concerning jurisdiction, provided that the underlying facts establishing jurisdiction appear from the pleading. For instance, an allegation that the defendant resides within the area of jurisdiction of the court may be an adequate prima facie allegation of jurisdiction. Likewise, an allegation that the delict was committed within the court's area of jurisdiction is sufficient to establish jurisdiction. Where, as in the present matter, statute prescribes the bases upon which a court exercises jurisdiction, it must appear from the pleading that the requirement posed by such statute, the Divorce Act, in the present matter, have been met. The plaintiff in a divorce action must thus allege and prove that the court has jurisdiction on the basis of either domicile or residence. Be very careful, folks, when pleading your jurisdiction in divorce matters. In other words, especially if you seek to rely on domicile, do ensure that you plead the sufficient facts underpinning your allegation that the court has jurisdiction. That was HGW versus MW, and that was from the Western Cape High Court. Next up, folks, we go to the South Gauteng High Court, Johannesburg, to the Court of Mitchell, AJ, in the matter of ES versus JHCS. This judgment can be found on page 101 of your bundle and on page 8 of your summaries. This is a very interesting judgment in terms of procedure, and if you do decide to read it, you will most likely have to read it 2 or 3 times to make sense of exactly what happened in this matter, just because it is so procedurally convoluted, and the way in which it is set out reflects that convolution by no fault of the presiding judge. I've done my best to summarize it for you with Atlechang's assistance as we prepared these notes. However, it is worthwhile reading this judgment, as no short summary is going to really give you the full picture, but I am going to try my utmost to do so. The matter deals with divorce amendment of a particulars of claim, removal of a notice of bar, and absolution from the instance. The matter concerns the attempt by Mrs. S to vary a 2004 divorce deed of settlement, which was made in order of court. Clause 3.1 required her to transfer property to Mr. S, her ex-husband, within 10 years, conditional on him settling the bond, paying transfer costs, and meeting monthly obligations. Upon transfer, Mr. S would pay Mrs. S 1/3 of the rental income in respect to the property. In 2023, nearly 20 years later, Mrs. S issued summons seeking to amend this clause. Mr. S accepted to her claim, successfully so, claiming a lack of cause of action. Though granted 30 days to amend her particulars of claim, she failed to do so after those proceedings, prompting a notice of bar from Mr. S's legal team. She then applied to uplift the bar and to amend her particulars of claim. She relied on Rule 42.1b, arguing that the omission of a clause granting her full ownership and rental income upon breach by Mr. S was a patent error in the original order. The court confirmed that the deed had been incorporated into the divorce order in May 2023. She then sought to replace specific paragraphs in the deed with a new wording. Once again, the settlement agreement did not make adequate provision for terms which became highly relevant at a later stage. The court looked in this judgment at Rule 27 of the Uniform Rules, note removal of or upliftment of notes of bar, Smith NO versus Brimmer, grounds for removal of bar, Rule 42.1b of the Rules of Court, in terms of setting aside. Folks, there is an error on your notes here. We say Rule 42.1b, amendment of pleadings. We know that is an amendment of pleadings. Rule 28 is amendment. Rule 42.1b is variation or rescission of judgment. Please just make a handwritten note. I will distribute new notes to those who have purchased after the presentation. Sorry for that clerical error. So the application for upliftment of the notes of bar and application for leave to amend are dismissed. Absolution from the instance is granted in favor of the respondent in terms of the applicant's cause of act or applicant's action, and the applicant was to pay the costs for all three applications on a party and party scale. So the applicant failing in all three of the applications, all of which really dovetailed, didn't they? Once again, a cautionary tale on drafting of settlement agreements, folks. The reality is the initial settlement agreement did not make adequate provision for something that clearly transpired at a later stage. Paragraph 28 is our notable quote, and it reads as follows. In Wolf, the court was dealing with a situation where a party was in default of filing a declaration. The court was dealing with simple summons for a debt or liquidated amount. In such case, the summons itself sets out in concise terms plaintiff's cause of action. Cause of action. When absolution is granted here, it is absolution from the concise cause of action set out in the summons. The position is different with a combined summons, and this was obviously a combined summons. Because when the particulars of claim are set aside, there is nothing in the summons to identify the cause of action from which absolution is granted. And the court then obviously electing to grant absolution from the instance. Very convoluted procedural judgment, folks. ES versus JHCS reads as a cautionary tale. Do read it and try and get your head around it. This is per Mitchell AJ in the South Gauteng High Court. Next up, we go to maintenance, and apologies, this one did not show nicely on my slides. We go to the matter of GPN versus CMN. It is a review matter in the Northwest High Court, Mahikeng. It is our second judgment penned by Titus AJ, and in this matter, it is Titus AJ drafting the judgment and Judge DJP concurring with the judgment. This is a review matter on maintenance proceedings regarding misconduct by an attorney. The judgment can be found on page 112 of your bundle and page 9 of the summary. Now, what vitiated the proceedings was that the attorney acting for the respondent in the maintenance proceedings did not have right of appearance at the time of the proceedings, which vitiated the proceedings as a whole. What had happened here? The review was brought at the request of the senior magistrate in Klabane Magistrates Court. The application, as I mentioned to you, was brought on the basis that the attorney who appeared for the respondent in the maintenance proceedings had no right of appearance. Now, what was covered in this judgment was Section 22 of the Superior Courts Act, grounds for review of proceedings. Section 24 and 33(1) of the Legal Practice Act, being a legal practitioner's right to practice. Bester versus Easy Gas, which sets out the principles for gross irregularity. Section 34 of the Constitution, being the right to a fair trial. The High Court agreed that a gross irregularity had taken place and that the proceedings were vitiated on that basis. So the maintenance inquiry is reviewed and set aside. The maintenance proceedings were to be heard anew before a new magistrate. Paragraph 6 of this judgment reads as follows. It is tried that the phrase gross irregularity in the proceedings envisages an irregularity in the conduct of the proceedings, not the result thereof. The irregularity must have been of such a nature that it resulted in the aggrieved party not having his case fully and fairly determined. The fundamental question then perhaps is whether the irregularity complained of prevented a fair hearing for the respondent at the maintenance inquiry. The proceedings, therefore, obviously set aside. Fascinating judgment on right of appearance. Candidate attorneys who might be tuning in today, listen up. Make sure you've got your right of appearance if you do go and appear on behalf of your principal. There are horror stories such as this. So, folks, reminder to those of you who are inclined to do so, you can purchase, sorry, my pronunciation on a Friday with an itchy nose. You can purchase the optional course pack for 300 Rand by going to thinklegal.co.za. That will get you a good 370 pages of judgments, which you would otherwise have to download manually from Safely or other sources. It will get you 17 pages of summaries, which are designed to fast track you into reading the judgments, and it will also get you to SAAM or social justice CPD points. Please, if you would like to support what we do here with the Family Law Roundup, we would appreciate you purchasing the course pack. If you are disinclined or simply unable to purchase the course pack, you are still more than welcome to tune in and listen to me go on a Friday morning and wax lyrical about the cases transpiring last month. A reminder to save the date for our paid CPD training, Divorce 101 on 3, 4, and 5 June 2025. Exact same cost as our other 2-night courses. This one gets you 1 extra CPD point, gets you 6 SAAM CPD points if you attend, which takes you nearly 60% to your required CPD allocation for re-accreditation. So if you do want to support us by attending Divorce 101, please go to thinklegal.co.za and register for Divorce 101. Next up, folks, we go into part 2 of the roundup, which takes us into the final half of the proceedings today. And we're going to start off with Rule 43, whereafter we're going into a whole wad of children's matters. We've got a good 7 children's matters to deal with, and then finally a matter involving burial rights from the Eastern Cape High Court in Tata, which we will have a look at. Right, first up, folks, Rule 43. We are going to start with the extremely aggressive initials in this matter, MCDR versus APWR. This is from the South Gauteng High Court in Johannesburg, in the Court of Pretorius, AJ. It is a Rule 43 matter for spousal maintenance pendente lite and a contribution towards legal costs. The applicant in this matter sought a Rule 43 order. Incidentally, for those of you following along, bundle page 119 and summary page 10, you can find this judgment. The applicant sought a Rule 43 order for maintenance pendente lite retrospectively from 1 December 2024, contribution towards her legal costs in the amount of 1.9 million rand. The applicant in her papers alleged that throughout the marriage, the respondent was the primary, if not the sole breadwinner, and that the respondent maintained her. Applicant and respondent's financial disclosure forms were considered by the court, as in most cases in the Gauteng High Court. The respondent's tender was considered by the court. The principles on tort versus tort were considered, and the parties' financial capabilities and standard of living was considered. The Rule 43 order was granted. Respondent was to pay 700,000 rand to the applicant's legal costs, or towards the applicant's legal costs. 15,000 rand per month in terms of maintenance ordered. Respondent was ordered to continue paying list of living expenses and costs to be costs in the cause. Now, what I found very interesting for the mediators out there, paragraph 105, both parties have pointed fingers at one another for not actively attempting to mediate the disputes between them. I accept that the applicant would not be in a position to consider mediating meaningfully, as she says, at this stage only, until she has received full and frank disclosure, which underscores the reality that in many instances, mediation may be premature until the parties have full insight into each other's financial affairs. That is MCDCR versus APWR in the Johannesburg High Court per Pretorius AJ. Incidentally, we're all waiting with bated breath to see what's going to happen with this mediation directive in the Gauteng High Courts. I've omitted it from the course pack today as it has not yet been implemented. They were distributed in draft form. see quite a lot of opinion pieces making their way to the newspapers, tabloids, websites, blogs, and not to be outdone, LinkedIn. I'd love to hear your views in the comments as well as on the WhatsApp groups regarding this. Although I don't have to ask about the WhatsApp groups, I've been following the conversations on the ThinkLegal groups throughout this week, although I haven't had the opportunity to chime in myself yet due to time constraints. But it is going to be very interesting to see what happens in terms of this directive. Many criticisms towards it, some unfounded, some fair, many extolling the virtues thereof, some unfounded, some fair. Only time will tell what is going to happen with this directive in the Gauteng High Courts. ML versus SJPL is our next Rule 43 judgment. This once again comes from the South Gauteng High Court, and you can find this judgment on page 164 of your bundle and page 10 of your summaries. This is before Muhammad J, and this is a Rule 43(6) for a further contribution to legal costs and maintenance pendente lite. The applicant sought an order in terms of Rule 43(6), citing changed circumstances where the previous Rule 43 order was granted in 2018. The applicant sought an order for maintenance to the amount of 32,613 Rand and an increase or a further contribution to legal costs of 50,000 Rand. The court considered S versus S, the purpose of Rule 43, the interpretation of the previous Rule 43 order, and the reciprocal duty of support. In this instance, the application was postponed sine die with the applicant to pay the costs. If you want to see a judgment where the Rule 43 was kicked for touch and postponed sine die, go and have a look at ML versus SJPL for the facts giving rise to this. Paragraph 9 is our notable quote. In S versus S, the Constitutional Court confirmed that the purpose of Rule 43 is to provide a speedy and inexpensive remedy for the benefit of women and children. It provides for interim relief in matrimonial disputes until the divorce court can properly make an informed finding after hearing oral evidence. The court has held that almost invariably women are at the lowest rung of the economic ladder and are generally in a less favorable financial position than their husbands. Paragraph 9 of ML versus SJPL. Next up, folks, we stay on Rule 43, and this is our final Rule 43 matter. This is the judgment of TAS versus IS in the South Gauteng High Court. It's an extempore judgment, Rule 43(6), variation of a Rule 43 order. The judge, once again, Muhammad J, and you can find it in your bundle on page 169 and page 11 of your summaries. The applicant brought a Rule 43(6) for an increase in spousal maintenance and a contribution to legal costs, a further contribution to legal costs. The applicant claimed in her papers that she's no longer able to sustain herself for the amount of 11,000 that was ordered in the Rule 43 order. The applicant further claimed that the 40,000 Rand awarded for legal costs or contribution to legal costs had already been utilized, and that future legal costs of 117,000 would be sufficient. Sorry, there's a spacing issue on my notes, folks, just at 117,000. Increased costs of daily expenses for material change in circumstances was taken into account and the respondent's financial position, or applicant and respondent's financial positions were considered. Apologies, it wasn't a spacing issue on the amount, it was a zero that was missing, 1.17 million rand sought. So the Rule 43 order was varied. The respondent was ordered to pay 180,000 rand for the applicant to purchase a vehicle. The respondent was ordered to pay an additional 5,000 rand towards spousal maintenance and a contribution to legal costs in the amount of 800,000 rand. And the cost of litigation to date reserved. Paragraph 4 is our notable quote. On the last occasion, no provision was made for normal escalation linked to the consumer price index. The court cannot ignore the reality of high costs of living and regular power tariff hikes. I agree that an increase of 5,000 rand per month is relatively small, and her client has provided a breakdown of expenses, and I had regard to submissions on the respondent's ability to pay as per his FDF. I consider the applicant's age in relation to the requirements in the job market and her training for any employment. Ms. van der Merwe correctly argued that the court must not lose sight of the fact that her client, too, is no longer a young person with high earning capacity. However, I noted the significant difference in total worth of the estates of each party and do not see this as an unreasonable demand and cost. TAS versus IS, South Gauteng High Court per Mohammed J. Next up, we go into a whole slew of children's cases emanating from Pretoria, Johannesburg, Pietermaritzburg, and Cape Town. So let's run through them. We have another 8 judgments to run through for this month's Family Law Roundup. First off, MME versus, and others versus the Director General, Department of Home Affairs, and another. This is in the Pretoria High Court per Millar J, and you will find the judgment at page 173 of your bundle and on page 12 of your summaries. The matter deals with the citizenship of a child born in South Africa. The first and second applicants, who are refugees from Rwanda, brought an application to secure South African citizenship for their youngest child, who was born after changes to the Citizenship Act. The applicant's eldest child automatically received South African citizenship at birth, but their youngest, born in 2015, did not qualify for automatic citizenships due to the amended Act that requires one parent to be a South African citizen at the time of birth. The applicant's request to have their youngest child recognized as a South African citizen was rejected by the first respondent, who argued granting citizenship would be ultra vires the Citizenship Act. The applicants contended that the decision should be reviewed and set aside, citing the provisions of Section 2.2 of the Citizenship Act, which prevents statelessness. The court looked at the best interest of the child principle, Section 2 of the Citizenship Act, Section 5.1a of the Refugees Act, and Section 21 capital B of the Refugees Act. The outcome essentially is that the decision of the first respondent not to register the minor child as a citizen of SA was declared unlawful and set aside. Respondents ordered to pay the cost of the application jointly and severally. Notable quotes from paragraph 38 to 40 of the judgment: the argument for the respondent, while necessarily following the letter of the law, pays no heed to the obligation upon them in the interpretation and application of the Citizenship Act to have regard to the best interests of the minor child in this matter. In cases such as the present one, it must not be forgotten that procedure is but a handmaiden of justice, and the cause of justice can never be allowed to be thwarted by any procedural technicalities. The circumstances in which the minor child finds herself fall squarely within the provisions of Section 2.2 of the Citizenship Act. It is constitutionally directed that a child is to have a nationality from birth, and it follows axiomatically that it is in the best interest of the child that this is so. In the circumstances, the minor child is to be declared a citizen of the Republic of South Africa. Something we don't see very often, a judgment relating to the Citizenship Act. Very interesting judgment, Millard J., North Gauteng High Court. Next up, we deal with relocation, and sure, we're seeing a lot of relocation these days, guys, internationally and locally. All of them essentially following the same principles, but obviously different outcomes based on the facts of each of these matters. This is SVDB versus HEVDB, and that is in the South Gauteng High Court in Johannesburg before Mohammed J, once again, who features quite significantly in this roundup. Page 185 in your bundle, page 13 in your summaries, you can find this matter. It's an urgent application for an interdict in respect of relocation of children. The applicant, the father, through an urgent application, sought urgent interdictory relief, preventing the respondent from relocating with their 2 minor children to Cape Town, pending the finalization of a psychologist's report. The applicant further sought an order for primary residence in terms of Rule 43.6, that the respondent was granted primary residence in the Rule 43 application. Section 31(2) of the Children's Act, due regard must be, or due consideration of wishes of a co-holder of PRR was considered. F versus F was considered, and LW versus DB was considered. The application for an interdict fails. The application for a grant of a primary residence fails, and each party pays their own costs. Paragraph 21 is the notable quote in this judgment. And it reads as follows. Let me just grab a sip of water. I mentioned earlier there is little before me regarding the children and volumes before me regarding the parties and their behaviors. They know their children. If there was any fact of substance against their move, I have no doubt it would have been before me. The usual issues of adjustment to new friends and environment is simply par for the course. The incomplete report cannot stand in the way of the life of the respondent. She is not only looking for a life-enhancing opportunity in Cape Town, she is asking this court to assist her in her attempt to survive and be a normal parent to her children. The court cannot deny her the support she needs, and it cannot be held hostage to the feelings of aggrieved litigants. And that is SVDB versus HEVDB, where the interdict against the respondent's move to Cape Town was dismissed. Next up, folks, apologies, I neglected to put the citation on your screen. SVDB versus HEVDB, it is on your screen now. Next up, we go to TMN versus YN, and this once again emanates from the South Gauteng High Court in Johannesburg per Markandonatos AJ. It is an urgent application dealing with primary residence contact and a forensic assessment. You can find the judgment at page 197 of your bundle and page 13 of your summaries. The father sought urgent relief over contact and care of his twin daughters with the respondent, who is the mother. Parties divorced in March 2022, agreeing that the children would primarily reside with the mother, while both parents would retain full PRR, ensuring unrestricted contact between the father and the minor children. In September 2024, the father sought urgent relief, expressing concerns over mom's alcohol use and an incident during a party at her home where a firearm was brandished in the children's presence. He claimed that during the event, the children were upstairs and potentially in danger. Mother acknowledged the altercation but denied that a firearm was discharged or that the children were at risk. Forensic assessment was conducted by Dr. Del Fabro, who identified concerns regarding both parents' alcohol use, co-parenting challenges, and potential parental alienation behaviors by mom. The assessment recommended that the children reside primarily with father, with supervised access for mom, and that she undergoes a comprehensive alcohol treatment program. Court considered the recommendations. The court considered to Blanche versus to Blanche being the upper guardian, Section 28.2, best interests, and McCall versus McCall on factors determining best interests. Application was granted, primary residence to vest with the father. Two notable quotes, paragraph 45 and paragraph 55 of the judgment. Paragraph 45, the level of acrimony between the parents and the minor children has reached a critical and dangerous level. It's clear that the disputes about the care of the children, which must be viewed through the prism of the Constitution and, of course, also in relation to the Children's Act 2005. Paragraph 55 says, having regard to the foregoing and taking into consideration the report and recommendations of Dr. Del Fabro, as well as this court's concern in respect to what can be best described as the cavalier, flippant, and lackluster attitude of the respondent, the manner she has chosen to deal with, or rather not deal with, the serious allegations and findings made in respect of her alcohol consumption, parental alienation, co-parenting challenges, and her neglect of doing enough to change her behavior in the face of the very serious allegations made of her. It is, in my view, that it is in the children's best interest that their residence is with the applicant, as this court cannot permit a situation to endure whereby we wait and see how the crisis will unfold and wait before taking any action, instead of having a pre-crisis plan in place before disaster strikes. That is TMN versus YN, Johannesburg High Court, per Markandonatos AJ. Next up, folks, DRR versus SDR and another, KwaZulu-Natal High Court, Pietermaritzburg, per Mossop J, bundle page 224 along in the bundle, page 14 in our summaries. This is a matter of primary residence, contact, and care in the face of allegations of substance abuse. Applicant brought an application against the first respondent, mom, seeking to be awarded primary care and residence over the minor children. Applicant and the first respondent had experienced a tumultuous relationship marred by frequent separations and dad's history of substance abuse. Mom also consumed alcohol and marijuana, but did not progress to harder substances. The court looked at some interesting factors here, van der Linde, and the principle that siblings should not be unnecessarily separated, the family advocate report and recommendations, to Blanche versus to Blanche, and then finally, obviously, the best interests of the child principle. In this instance, primary care and residence of the children were awarded to mom. Applicant granted contact, no order as to costs. Paragraph 78 being our notable quote, there are other convincing reasons why siblings should be kept together where possible. One obvious reason is that children learn not only from their parents, but also from their brothers and sisters. Sharing a home and a relationship with a sibling allows a child to observe, copy social skills already possessed by their sibling, and being with a sibling helps the development over time of emotional intelligence. There are a myriad of benefits that have contributed to the conventional wisdom that children born to the same parents should be kept together and raised to adulthood together. Interesting judgment, Mossop J, DRR versus SDR in the KwaZulu-Natal High Court, Pietermaritzburg. Right, next up, we go to SP versus SH. That is in the Johannesburg High Court before Friedman AJ. And this is regarding the appointment of a parenting coordinator and contact. Now, this judgment can be found on page 253 and page 15 of your summaries. In April 2021, applicant filed an urgent application for contact with minor child T. Court under Justice Valley issued an order providing for further investigations and therapy for T and set arrangements for contact between the parents, confirming they shared PRR. Main issue was Part B of the applicant's April 2021 application and the respondent's counter-application, both of which had been amended. Applicant's preferred outcome was to refer the matter to trial, proposing that T primarily reside with him, respondent having reasonable contact. Respondent's proposed order included confirming her as T's primary caregiver, with the applicant having defined contact rights and appointment of a parenting coordinator to assist with co-parenting. Interesting reports from the family advocate, taking into account the family advocate's first and second report, psychologists' expert reports, best interest of the child principles, to Blanche versus to Blanche, Hummel versus Hummel, TC versus SC, and then section 33.2 of the Children's Act regarding parenting plans. Order granted. Applicant and respondent to remain co-holders. Primary residence awarded to respondent. Applicant granted contact. Parenting coordinator appointed, and parties to pay their own costs. Paragraph 74 is our notable quote, friends and colleagues, and it reads as follows. It is well accepted that in matters concerning the best interests of the child, we do not approach motion court proceedings by applying Plascon-Evans strictly. What this means is that despite what would be described as genuine disputes of fact in normal motion proceedings, it may sometimes be necessary to grant the applicant relief. In other words, a court should look at the evidence as a whole and decide what order would most appropriately vindicate the child's best interests. Simply deciding the matter on the respondent's version, as Plascon-Evans would require, may be inappropriate, but so too may a referral to trial. I return to this issue below. Friedman AJ electing not to kick the matter down the road to trial and deciding the matter on motion, despite Plascon-Evans principles, which we know can be tempered in matters relating to minor children. SP versus SH. Next up, we go to the Western Cape High Court, once again, the Court of Tulare J. This is YS versus SS. You can find it in page 325 of your bundle and page 15 of your summaries. This is an urgent application for the appointment of an educational and a child psychologist. It also deals with parental responsibilities and rights. The applicant brought an urgent application seeking the appointment of an educational and a child psychologist to conduct an assessment relating to the parties' PRR. The applicant further sought to regulate supervised contact with the child pending the report, and for the respondent to pay the costs of the application on attorney and own client scale. The court looked at Section 9 of the Children's Act. The court looked at P versus P. Whilst PRR should be respected in matters dealing with minor children, the court has a duty to inquire whether any arrangement to enforce PRR is in the best interests of the child. Thank you so much, Jen and Minka, for your kind words regarding the bundles. I really appreciate your feedback, and I will also convey your feedback to Atlegang, who assists me in pulling all of these notes together on a monthly basis. I really appreciate the kind words. So in this matter, the appointment for a new educational and child psychologist is dismissed. Social worker from DSD is appointed to supervise contact. The appointment of the current clinical psychologist remains in place. The clinical psychologist shall continue with the investigation, and supervised contact is granted to the applicant. Paragraph 12 is our notable quote from the judgment. The application, instead of confronting the devil that the clinical psychologist has illuminated for him, is but an example of the length to which the applicant would stretch in the contest for strength and dominance. To avoid being seen making his own son an adversary, he blamed the respondent for the son's own decisions. The applicant must strive to understand how his own son perceived him and then strive to work on the emotional levels where he and his son experience each other. Strong words. Blaming the respondent for his own shortcomings was not helpful. The applicant's impatience with a gradual and phased-in approach does not make the clinical psychologist wrong or biased. An urgent application should never be confused for an instrument towards an impetuous decision. A very interesting judgment by Tulare J. for those dealing with parental alienation versus parental estrangement matters at the moment. Well worth a read, particularly if you take paragraph 12 into consideration, where the court has some strong words to say to the applicant regarding taking a look at himself in the mirror and questioning or evaluating his own conduct, which may have led to the decline in relationship. That is YS versus SS, Tulare J, Western Cape High Court. Next up, AVS versus HVS, once again, Tulare J, Western Cape High Court, 17 March 2025. Urgent application, rule nisi, primary care, and reasonable contact. That's page 337 and page 16 in your summaries. The applicant, mom, sought an urgent application for primary care of the child while an investigation was conducted by the family advocate. The respondent opposed the application, seeking maintain control over the child's living arrangements. The dispute stemmed from their strained marriage and the applicant's mental health challenges, which the respondent attributed to substance abuse, though there was no evidence of such claims. The applicant had voluntarily checked herself into a psychiatric hospital following a motor vehicle accident, after which the respondent took the child to his mother's home in Bredasdorp without the applicant's consent. He sounds lovely. The respondent set conditions on the applicant's access to the child, exacerbating the tension between the parties. The court looked at MEC for Department of Health versus Department of Health Eastern Cape versus M principles of rule nisi, investigation by the family advocate. The applicant's mental health concerns, as well as domestic abuse perpetrated by the respondent, were considered an infringement of the applicant's rights, parental responsibilities and rights. The applicant succeeds. A rule nisi is granted in respect of reasonable contact. The respondent is ordered to pay the costs. Paragraph 8 of the judgment is instructed in this regard. The applicant sought interim relief to adequately protect her interests. The applicant's parental rights were infringed, and it was clear that she would suffer a disadvantage if the court did not intervene. The rule is flexible and can act as an interim order. The applicant would not gain any advantage on the return date, which she would not have otherwise had. It seemed to me that the applicant might be a victim of domestic abuse who developed panic symptoms when traumatic experience of her marriage were triggered. It also appeared to me that the applicant may have been exposed to severe and ongoing threats to her integrity, and now her care and contact with the child were being not only threatened, but also infringed by the respondent's extrajudicial orders and conditions. This is AVS versus HVS per Tulare J, Western Cape High Court. Right, folks, and as we come to the last judgment in our family law roundup this month, we go to the topic of burial rights. I don't know why my last judgment never displays nicely on these slides. I do apologize for that. But nevertheless, the judgment is Mbalane versus Mbalane and others, kept for last, since I get to pronounce a name and not just initials a la Poppy Act. Mbalane versus Mbalane and others, ZAECMHC 14 for March 2025, and that is Singani Mbakaza AJ. So very interestingly, why other family law matters restrict us to initials while customary law matters don't. Anyone have any idea what's up with that? If you could let me know in the comments or on the WhatsApps, I would be very interested to learn. This is an urgent application in respect of burial rights and exhumation in the Eastern Cape High Court, Mthatha. The judge, Singani Mbakaza AJ, bundle page 343, summary page 17. The applicant sought an urgent application to exhume and rebury the body of the deceased who was initially buried at the first respondent's home. The applicant and the first respondent were in a romantic relationship in which they had 4 children, including the deceased. Deceased was buried at the first respondent's place by agreement between the parties. The applicant alleged in his papers that the parties agreed that after the deceased's funeral, the deceased's body would be moved and reburied at the applicant's home according to their customary rights and beliefs. Rule 612 of the Uniform Rules considered urgency. Mankakla versus Matiwane considered rights to make arrangements for deceased. Kumalo and others versus Kumalo and another is of the deceased entitled to right to make arrangements for the deceased considered. The application fails. The application for the exhumation of the deceased body was dismissed. Applicant to pay the costs. Notable quote in this judgment. A well-known principle has been reiterated that there is no explicit indication as to who shall be responsible for the burial arrangements. As in the present case, the heir or the heirs of the deceased shall be the persons responsible for the disposition of the deceased's body. Moreover, where there are multiple heirs, the common sense approach in deciding burial rights prevails. The applicant not succeeding in the urgent application, despite the alleged agreement that the exhumation take place. Folks, that is the Family Law Roundup, March 2025. 18 judgments we worked through today. I think some very interesting ones. I'd love to hear from you on the WhatsApp groups what you found particularly interesting in the roundup today. Reminder to go to thinklegal.co.za as we wrap up the roundup, register for events, join our groups, purchase resources, or view past webinars. As always, thank you to Lawbox, as well as my colleagues at Vermeulen Attorneys for assisting me and allowing me to do the roundup every month. Final big thank you to all of you for attending. Extra big thank you to those of you who have purchased the course pack. It really helps me to feasibly do this to do this on a monthly basis. I really do appreciate all of you. Looking forward to seeing all of you in the community, and we will touch base there. Interesting question. Tulani asked, can we mediate this last case? I'm sure it can be mediated. Difficulty is there was a dismissal of the urgent application, so there was also already a type of a declaration of rights or some indication on rights. So wouldn't the mediation start off on a very unequal footing? The party who was successful might not be very inclined to mediate, but as we know, anything can be mediated essentially. So guys, thank you so much. have a great weekend. I'm going to end the stream now, and I look forward to chatting with all of you further on WhatsApp, and I will let you know if I have any information regarding why customary law matters do not have the same courtesy of abbreviated letters that other family law matters do. So thank you, folks. Have a lovely weekend, and I'll see you at the next one. And I'm ending the stream in 5, 4, 3, 2, 1. Good.